Today, we're talking about what happens if the doctor refuses to answer my questions during his pretrial testimony. You want to know what this is all about? Come join me for a moment as I share with you some great information. So, I use this type of graphic when I'm doing Facebook Live videos. And it's really interesting because I use it as a little ticker tape to show people, what the topic is, what the title is that I'll be talking about. But today I wanted to shoot a great video, an educational video, to help you understand what really happens if I'm at a deposition, which is a pretrial question and answer session, and the doctor refuses to answer my questions. Come join me for a moment as I share with you this terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now here's the scenario. You've brought a lawsuit against your doctor claiming that he violated the basic standards of medical care. You believe that your doctor was careless, and as a result of his carelessness, it caused you significant harm and injury. And now you had no choice but to bring a lawsuit against him. Why? Because your doctor wasn't voluntarily going to take out his checkbook, write a check for all of the pain you suffered, all of the injuries you suffered. So instead, you had no choice but to bring a lawsuit against him, to try and obtain money as compensation for all of the harms and losses and injuries that you suffered. All right, so now what happens next? What happens next is that after you start your lawsuit, the doctor gets those lawsuit papers, he looks at it, he reads it, he sends it off to his attorney, and you know what they say? They say, "Why are you suing me? I did nothing wrong. I don't understand." So now that's his first defense. Number one, I did nothing wrong. Number two, he turns around and says, "You know what? If I did something wrong, guess what, Mr. Patient? So did you." Then he turns around and says, "You know what? If I did something wrong, you know what? Whatever I did or didn't do did not cause or contribute to your injuries." That's defense number three. And then what happens next? So then he argues, "You know what? If I did something wrong, and I may have caused you some sort of injury, and you also contributed to your injury, well, guess what? Your injuries really are not as bad as you claim them to be." So now, basically, the doctor is fighting, I'm holding a piece of paper right now, the doctor is fighting tooth and nail. You say day, he says night. Whatever you argue, he says just the opposite. That means it's a hard-fought, contested case. And now, your case will go through the litigation process. And during the course of the litigation process, the defense lawyer, the attorney representing the doctor whom you have sued, will have an opportunity to question you. It's a question and answer session. It takes place in your lawyer's office. Legally, we call this a deposition. It's also known as an examination before trial. Now, that's actual pretrial testimony. That testimony, even though it's given in the attorney's office, and by the way, there's no judge there, there's no jury present, but there is a court reporter there to record all of the questions you are being asked and all of the answers that you're giving. So, what happens next? What happens is that what most people don't realize is that even though you're in an informal setting, every answer you give represents a testimony, pretrial testimony, that carries the same exact weight as if you are testifying at trial, in court, in front of a jury. That's why it's critically important to understand what these questions are and to give answers that you know to be true. So now, what happens after that? After the defense lawyer has an opportunity to question you, he could be there for hours and hours or even sometimes days. What happens next is a few months down the road, we have an opportunity to go ahead and question the doctor whom you have sued, known as the defendant. The person who's bringing the lawsuit is called the plaintiff. The person who's defending the case, who's being sued, is known as the defendant. These are civil actions, civil cases trying to obtain money as a form of compensation. All right, so what happens next? Well, remember the title of this video? It says, "What if the doctor refuses to answer my questions?" Now, you should know, when I have an opportunity to question the doctor during his question and answer session, now we go to his lawyer's office, we're sitting in his lawyer's conference room, the doctor's sitting at the table, the doctor's attorney is sitting there, a court reporter is there, and I am there to ask the doctor questions. The doctor is not going to be very forthcoming. Most of the time, the doctor is extremely unhappy, he's got a scowl on his face, he does not want to be there. So now, there's going to be a certain series of questions that I'm going to ask the doctor that he's not going to want to answer. I guarantee it. Let me just share with you a little secret that you may not be aware of. Every attorney going in to question a doctor during his pretrial question and answer session has an agenda. At least every good experienced attorney in New York that I know, they have an agenda. And there's a key reason why we need to go through and accomplish and achieve the goals for that agenda. You want to know why? Because if I'm able to ask a series of questions that focuses on my agenda, I have the ability to prove our case before we ever even get to trial. I have the ability to get the doctor to answer my questions about what was the standard of care at the time. What was appropriate medical treatment when a patient comes in complaining of the following things? What should a good doctor do in that instance? So in the doctor's own words, I'm getting him to tell me what the standards of care were. Later on, I will then compare and contrast to what he actually did. But more importantly, my agenda is to get the doctor in his own words to tell me what was the standard of care. And he has to do that. And all these doctors willingly and eagerly tell me what the standards of care were. Why? Because they want to come across as the expert. They want to come across as the doctor who knows everything about this particular topic. That's great. But what's the rest of my agenda? The rest of my agenda concerns what we call hypothetical questions. Doctor, I want you to assume the certain facts to be true. Now, you should know that because this doctor contests practically every single thing in this case, you say day, he says night. You say he did something wrong, he says no, I didn't. Okay? Because of that, now I have to ask the doctor that our set of facts are true. He's not going to want to do that. He knows what's coming. His attorney has prepared him for this. Why? He knows what's coming. His attorney has prepared him for this before we begin our question and answer session. He knows that I'm going to be asking him hypothetical questions. And he does not want to agree with our set of facts. He disputes many of them, if not all of them. I am permitted during this question and answer session to ask the doctor hypothetical questions. Doctor, I want you to assume that on January 1st, my client came to you with a complaint of a breast lump in her right breast at the 12 o'clock position. Assume those facts to be true. Now, the doctor may disagree with that set of facts. His office records may indicate something totally different. May say that the patient came in with a different complaint and did not make a complaint of a breast lump. That's entirely possible. But whatever his set of facts, whatever his version is of the facts, I am still permitted to ask him the question, Doctor, I want you to assume these following facts to be true. Once I get him to accept that those facts are true, now I will ask him, Doctor, in that instance, would you agree that it's good medical practice to take a detailed medical history from the patient? Now, something as simple as that, he's got to agree with. Yes, of course I'd agree with that. And then I'm going to ask him, why? Why is that important? And now he'll give me a long-winded answer about why it's so important for a doctor to take a detailed, thorough medical history. And again, that shows me the standard of care for somebody with a complaint involving a breast lump, for example. Doctor, I want you to assume that after she complained of a breast lump, now you would agree that good medical practice requires that you perform a physical examination on the patient's breast. True? Yes. And the reason why you do a physical examination is to evaluate the patient's complaints, correct? Yes. And the purpose of doing that is to see whether or not you can feel and replicate the lump that the patient feels. True? Yes. And part of good medical practice requires that you, the doctor, who now is presented with this particular complaint, do this physical exam both while the patient is sitting up as well as lying down. Isn't that true? Yes. And why is that, doctor? So now I'm giving him an opportunity to explain why it's appropriate to do a physical examination both sitting up and lying down. Now, in this particular set of facts, I know that my client has testified before that this doctor did not do a physical examination at all. He basically said, let's hold this off. Okay, we're not going to do a physical now, nor did he ever refer the patient out. And I know that the doctor knows my client has testified to those set of facts. The doctor does not want to acknowledge that our facts are true. Why? Because he doesn't want to give any credibility to my client who's now bringing this lawsuit against him. So what if instead he turns around and says, you know, Mr. Oginski, I don't agree with your set of facts. I'm not going to answer your question. They're based upon a whole set of facts that are totally inappropriate. What do I do in that instance? Remember, there's no judge present in the defense lawyer's conference room. So what exactly do I do? Well, I'm going to remind the doctor that he's required to answer all of my questions unless his lawyer says the question is inappropriate, what we call palpably improper, or my question asks him to discuss conversations he had with his attorney. that's known as privileged conversations. Communications between himself and his lawyer are confidential, and I can't get the details of those conversations. In those two limited instances, his lawyer would be totally within his right to tell his client, the doctor, do not answer Mr. Oginski's question. They're inappropriate. Ask your next question, counselor. Those are the only two instances where the doctor can validly turn around and say, I'm not answering your question on the advice of counsel. That's fine. But now, when I ask him hypothetical questions, he is now required to answer my questions. And I'll tell you why this is so critical. After I ask him all of these factual questions, assuming our facts to be true, now, at the very end of those series of questions, I'm going to turn around and say, Doctor, I want you to assume that the following things were not done. If the following things were not done, would you agree that it would be a departure from good and accepted medical practice not to do A, B, and C? Either he's going to say, no, I don't agree, or he's going to say, I'm not answering that question. If he says, I'm not answering that question, now I'm going to put pressure on the doctor. Doctor, you're required by law to answer these questions. I don't care what the law says. I'm not answering your crappy question. This is bullshit. So now I may appeal to his attorney. Hey, counselor, do me a favor. Tell your client he's got to answer these questions. So now he's got no choice. He's going to tell the doctor, answer the questions. Whether you like it or not, you have to answer them. And the doctor knows that the key reason why I want to ask him these hypothetical questions is for the key reason that when we get to trial, maybe a year and a half, 2 years down the road, now, how do we use this scenario? How do we use these hypothetical questions? At the time of trial, I will now ask the doctor the same series of hypothetical questions. And the goal is that if the jury ultimately believes our set of facts to be true, or to be more like, I should say, let me go back for a second. If at trial the jury believes our set of facts to be more likely than not true, now the doctor will have testified in his own words that failing to do A, B, and C was in fact a departure and a violation from the basic standards of medical care. That's how we help prove our own case, through the doctor's own words. So what I'm really trying to do is to get the doctor to admit that if a doctor did not do these things, it would be a total screw-up. It would be carelessness. It would be medical negligence. And that's why I want the doctor to answer these questions. That's why the doctor does not want to answer these questions, because he knows that at trial, if the jury turns around and believes us, that we are more likely true than not true, now I have all this ammunition from the doctor himself that you have sued, that if a doctor did not do the following things, yes, it would be a violation from the basic standards of medical care. And yes, that would have caused the patient the following injuries. That's why a really smart, experienced attorney has an agenda during the course of this pretrial questioning. That's why it is so critical for an attorney during pretrial questioning, during this deposition, this examination before trial, to get the doctor to answer these hypothetical questions. Because once I get him to admit certain things through hypothetical questions, I don't care if he disagrees with it. It doesn't matter. What's critical is that he does answer the question. Ultimately, he's going to look very foolish and very silly if he turns around and argues with me repeatedly about the fact that he's not answering the question. Oh, so let me tell you what happens next if the doctor still refuses to answer my questions. So I've now reminded the doctor he has to answer. His attorney has now told the doctor, listen, doctor, you got to answer the question. Then what I do is I'll say, doctor, listen, I'm going to have to call the court. The court is now going to have to make a ruling. And then if you continue to obstruct my questions, the judge can, in certain instances, can fine you, can sanction you, and in worst case scenario, he can dismiss your answer from this case. It's called striking the defendant's answer. Now what does that mean? I'll tell you what it means. So let's imagine you go to a Yankees game, right? The Yankees are playing the Mets. And for whatever reason, the Mets don't show up. Well, the Yankees get an automatic win by default. Hey, the Mets didn't show up, we win. Okay, well, it's not very satisfying for you to watch that, to be in the stands, and the Mets don't show up. But the reality is, the Yankees just won. They didn't win on the merits, they won by a technicality. So now, in the same scenario, where now the doctor's refusing to answer my questions during his pretrial questioning, okay? If he refuses to answer, I have the ability to call the court and to ask the judge for a ruling over the phone, to try and get this doctor to force him, to compel him to answer my questions. What if he still won't do that? Or what if the judge refuses to take this request by telephone? Well, what will happen then is I will move on to other questions. And then, after we are finished with that question and answer session, I will then, in writing, ask the court to take action. I will then ask the judge to fine the doctor and to sanction the doctor and to compel him and force him to come back to the attorney's office to go through another question and answer session, which is going to take up even more time. And then I'm going to ask the judge to strike the doctor's answer so that we get an automatic win on liability. That's the extreme scenario. And there are some instances where a judge, reading the transcript of what went on during the question and answer session, realizes that the doctor was totally obstructing the process. The doctor refused, even after being told by his lawyer and being coerced, he still refused. The judge can strike his answer. And just so you know, when we start the lawsuit process, we do that by preparing documents called a summons and a complaint. We file it with the court and then we deliver it to the doctor. The doctor and his attorney in response have to answer those allegations. And what do they call those papers? An answer. And if the judge actually strikes the doctor's answer, it's as if the doctor never answered the lawsuit, which means we get an automatic win on liability. So now all we have to do is we have a trial just to determine how much money you are to receive as a result of all the harms and losses and injuries that you suffered because of this guy's carelessness. So the jury will never have to get to the questions of, was the doctor careless? Was his carelessness a cause of your injury? They no longer have to evaluate those two questions, which are critically important. So when we get that automatic win because the doctor's answer is now stricken, the jury only has to focus on the amount of money they are going to give you to compensate you for your harms and injuries and all of your damages. That's a key distinction here. So if the doctor turns around and decides, you know what, I'm not going to answer Oginski's questions, well, guess what, doctor? We're going to bring you back another time. And if you still obstruct and still create a problem and still refuse to answer my questions, now I have the ability to go back to the court and to show him the transcript, the questions and answers about the fact that you are refusing to answer proper questions. That's a key strategy, when used properly, can be devastating in a medical malpractice case here in New York. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I hope this has been eye-opening, I hope it's been a bit entertaining, and I hope it's been helpful for you to understand what occurs when a doctor refuses to answer a question or a series of questions during the course of his pretrial question and answer session here in the state of New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a fantastic day.